I'm coming, y'all. I'm trying to get the document up. All right, just 1 minute. All right, sorry about that, y'all. Can y'all hear me? Oh, ooh, Jesus. Y'all just won't let us. Oh, I did say I'd come back. Can you hear me? Can you hear me? It's gonna be a first week read, y'all. First read. All right. Let me address something real quick, right? Of course, there's always the lies, right? There's always the lies, always the lies. Let me say this. Ooh, I by no chance think that I am in charge of Oko, nor did Larry leave Oko to me. All right. Also, um, it was said. Well, let me make sure I call the name out by Brooke that I, for some reason, sought her out. I have no idea where she get that from. Just more lies. I did not seek you out, and for what would I seek you out for? Number two, I didn't buy no subs. Fat Boy bought 200 subs. I have over 1,000 myself. Okay? Now, I've been real easy, real quiet, and real nice, right? Because I told you I don't give a shit. But apparently, y'all want me to give a shit. Now, I'm going to tell you this right now. I will drop real receipts and let it tell the real story. I drop some calls. I drop the motherfucking goddamn, all the motherfucking text messages. But here's the thing. I drop them to somebody's parents. Initials of D and E. Okay? Now I put that on everybody's mama. Keep on fucking with me, and the landscape is gonna fucking change. I'm not gonna say nothing else. One more time. You sit up there and believe that bullshit if you want to. If you think that's how it motherfucking went, believe that bullshit if you want to. But I got time for that bullshit. Swear. Anyway, okay, let's get to what I have y'all here for. Where's the goddamn paper? Yeah, it can be located just like that, just that quick. And I believe D and E is not quite 60 yet. Don't fuck with me. All right, y'all, I'm finna bring it up. All right, this is gonna be my first read. Oh Lord, I ain't even said hey to the folks yet. Lord, I'm gonna say hey to y'all. Let me get it. Come on. And I have a lot of people asking me to do a breakdown on it. And this is gonna be my first read, but let me go through and say hello to y'all. Cause as always, I'm glad you decided to come on through. Let's see. What up, Star? What up? Hey Valencia. What's up, Jennifer? Karen J. What's up, Bev Davis? Let me see. Robert Keller, what it do, boss? What it do? Wifey. Let's see. Kayla. Yes, ma'am. What's up? Midnight Oasis. Karen Johnson. Uh-oh. Mertice Bolam. I said that. Peter. Atmos. What it do, boss? What it do? Hey, Jacqueline Jones. Hey, Nikki Leonard. Got your message. Did I say hey, Bev Davis? I thought I said hey. I'm coming, y'all. I'm trying to get the document up. Oh, shit. Hold on. Hold on. Sorry about that. Hold on. Shit. My ass is off. Hold on. I said Karen J. I'm thinking. Spiritual Gangster. What it do? Who else up in here? Hey, Chanel Lewis. V Rock. V Rock. Okay. So, Atmos has already read it. So, but this is going to be my first read, and let me see what we have. All right. Now, we're waiting on two things. I don't know when the other ruling is going to come, but we're waiting on two things, right? Now, this is the, okay. This is from the government, right? And it says, Dear Judge Donnelly, the government respectfully submits this letter response in opposition to the defendant's motion to dismiss filed on August the 9th, 2021. All right, so this should be an easy question, right? I know this late, but it's real easy. All right, so this response, this is a response to the defense motion, right? Hold on. With regards to the matter of law. This is the one where they're responding to the matter of law motion that was put in prior to, that goes in right after, when I told you, right after the government case has been submitted, right? So this is the government response to that. I'm coming, y'all. I'm getting a blue circle. I'm so sleepy, Jesus. All right, so this is a matter of law. Okay. All right. And I'm going to read. All right. All right. It says the government respectfully submits this letter response in opposition to the defendant's motion to dismiss filed on August the 9th, 2021. All right. And then that's a reference. The defendant moves purportedly pursuant to reference to dismiss racketeering acts 1 through 3, 7, 10, 12, and 14 of count 1, 2, counts 6 through 9, and 3, the entire indictment for lack of venue. For the reasons set forth below, the motion is both untimely and meritless. It should be denied in its entirety. The motion is untimely. In a transparent effort to avoid a finding that his motion is untimely, the defendant asserts that his motion is made pursuant to Rule 12b-2 of the Federal Rules of Criminal Procedure. Defense motion at 3. His assertion does not make it so. Rule 12b-2 provides that a motion that the court lacks jurisdiction may be made any time while the case is pending. Reference. Here the defendant does not assert that the court lacks jurisdiction. Instead, he asserts that 1, certain racketeering acts and substantive counts should be dismissed because they fail to state a claim under New York law. 2, once the court dismisses those racketeering acts and counts, this results in a lack of venue in the Eastern District of New York. 3, certain racketeering acts related to the creation of child pornography should be dismissed because there is no evidence that the visual depictions exist. And 4, certain racketeering acts should be dismissed because they are purportedly beyond the applicable statute of limitations. Reference. Notably, the federal rules make clear that motions alleging a defect. Let me get my glasses. Oh, God. Sorry, y'all. This is starting out rough. All right. Notably, the federal rules make clear that motions alleging a defect in instituting the prosecution, including improper venue, and the defect in the indictment of information, including failure to state an offense, must be raised by pretrial motion if the basis for the motion is then reasonably available and the motion can be determined without a trial on the merits. Reference. The federal rules further provide that the court may set a deadline for the parties to make pretrial motions. If the court does not set one, the deadline is the start of trial. Reference. If a party does not meet the deadline for making a Rule 12b-3 motion, the motion is untimely, but a court may consider the defense objection or request if the party shows good cause. Reference. Properly construed, there can be no doubt that the defendant's motion is, in fact, a Rule 12b-3 motion. Apart from his initial invocation of Rule 12b-2, without more, the motion is replete with references to the fact that the defendant is challenging the sufficiency of the indictment. So that is what that matter of law motion is about. Remember, I told you that the defense was saying that with regards to those challenges they made, I guess with regards to the uncharged acts. This is just the uncharged acts, right? Based on that, they're saying that the evidence is insufficient and that no jury can make a reasonable judgment based on the evidence that's being submitted with regard to those acts in the uncharged acts. So let's see. It says, indeed, his argument with respect to racketeering acts 12 and 14 of count 1 and count 6 through 9 is that these racketeering acts and counts fail to state an offense because the underlying state law violations on which they rely either 1, do not include herpes, or 2, the indictment does not allege conduct amounting to reckless endangerment under state law. Item A 5 through 10. Nor is his meritless statute of limitations argument jurisdictional reference, claimed that indictment charged offenses beyond the applicable statute of limitations was not jurisdictional. Finally, his claim that venue in the Eastern District of New York is improper falls squarely under Federal Rule Criminal P 1216, I'm sorry, 12B3AI. Here, the court set a deadline for the parties to make pretrial motions. Following several adjournments of the trial date, on February the 9th, 2021, the court set a July 19th, 2021 deadline for such motions. With the government's consent, the defendant moved for a 1 week extension to the motions deadline to July 23rd, 2021, which the court granted. As a result, the defendant motion filed on the morning of jury selection is untimely. Oh boy. Okay. The defendant has provided no good cause for his untimeliness, nor could he. The defendant's suggestion prior to the start of jury selection that he needed recently produced discovery to make his motion is baseless. Reference. See transcript criminal cause for jury selection on August 9th, 2021 at 6. His motion to dismiss the racketeering acts and counts related to herpes exposure and the correlative venue challenge are based on misguided arguments as to the reach and applicability of the underlying state laws at issue, not any substantive evidence produced in discovery. Indeed, that is why the defendant previously filed a motion to dismiss the very same racketeering acts and counts related to herpes exposure over a year and 4 months ago on March the 2nd, 2020. And that's one of the ones we went back and looked at. Remember, I went back and put up the motions to the two motions to dismiss. Remember, I was explaining a couple lives back that Greenberg they just tried to dismiss like a count instead of try to break the legs off like Nicole and Farinella did. So I guess it's a good thing we went back and looked at that. All right, it says the same is true with respect to the defendant's argument regarding the statute of limitations. As a result, the motion should be denied. So, let me see. Let me just look at something real quick. The deadline to make retrial for motions. So, if they're asking for a dismissal on an untimely motion, chances are she's gonna grant that. She's gonna deny that motion if it wasn't put in on time. And the defense, and from what the government says, the defense didn't even give a good reason for the basis of the motion being untimely. Like it stated, they give you the motions. Some motions have a time. Well, all motions have a specific time to have it in, and as the document said, or if it's not stipulated, then it is ahead of trial. That because that motion had a date, expiration date, for when they had to get it in. Remember, and they had an extension on it. Therefore, that ruled that motion untimely. So I'm pretty sure, unless she's feeling real lenient or what have you, or she may just look at what has gone on in the case within the last few weeks, as far as them submitting those uncharged acts and what have you. She may cut the defense a break, but she may just deny it outright from being untimely. If she does that, we should get that motion back fast. We should get that one back real fast, because it's nothing for her to look at. All right, because remember, the motion that she had in front of her was a matter of law motion, right, which required her to do make a interpretation of the law prior to going into the trial before it gets in front of the jury, and which is called a redirected verdict made from her. If the government is saying that that motion was untimely, then she really doesn't have anything to look at. So we should get that response back fast if she's going to deny it. If she's actually considering that motion that the defense put in, then you know, it should come with an explanation, an elongated explanation as to why she denied it, and probably with respects to each count. Normally, if it's going to be come back in as a motion denied from being untimely, it's not going to have, unless she just feels like formatting it or whatever. It shouldn't have a lot of verbiage as to why it was denied. It was denied because it's untimely, and that's pretty much how it should come back. Let's see. Okay, the motion also fails on the merits. All right, let's see what this says. The charges related to herpes exposure should not be dismissed. Okay, let's see. Count 6 through 9 and Racketeering Acts 12 and 14 of Count 1 each relate to violations of the Mann Act. More specifically, these racketeering acts and counts collectively allege that on and about May 18, 2017 and February 2nd, 2018, the defendant, 1, transported Jane Doe number 6 in interstate commerce with the intent that Jane Doe number 6 engaged in sexual activity for which a person can be charged with a criminal offense. Okay. Specifically, violations of New York Penal Law, Section 120.20. Okay, a whole bunch of references. Let's see. Okay, and New York Public Health Safety Law, Section 2307. Reference. And second, persuaded. What is that? Induced, enticed, or coerced Jane Doe number 6 to travel in interstate commerce to engage in sexual activity for which a person can be charged with a criminal offense. Specifically, violations of Section 120.20, reckless endangerment, and Section 2307, exposure of infectious venereal disease, and violation of 18 U.S.C. Section 2422A. The indictment further alleges that the defendant violated these New York state laws, specifically by engaging in unprotected sexual intercourse with Jane Doe number 6 without first informing Jane Doe number 6 that he had contracted herpes and obtaining her consent to sexual intercourse in these circumstances. So right there, you know what they can do? They can say, one, he didn't get her consent, he didn't tell her that he had herpes, and two, he didn't have her consent to have intercourse with him while having a sexually transmitted disease. The prosecution can point out that no reasonable person would consent to having sex with somebody with the sexual transmitted disease. That's a way of putting that in paper form as a part of your case. Let's read. Okay, New York Public Health Law, Section 2307 applies to herpes. Okay, New York Public Health Law, Section 2307 provides that any person who, knowing himself or herself to be infected with an infectious venereal disease, had sexual intercourse with another shall be guilty of a misdemeanor. The defendant argues that it is undisputed that Section 2307 does not include herpes. Reference. He is wrong. Herpes is clearly an infectious venereal disease, and as a result, Section 2307 encompasses herpes, as New York state courts have repeatedly found. Okay, so they give case law. So they give case law to find that in a decision that seemed to be favorable to the prosecution, they did find that herpes is a infectious venereal disease. So most likely she's probably gonna allow this. It says provides basis for a valid civil claim where husband failed to disclose to his wife that he had herpes before sexual intercourse. Case law. In civil case where plaintiff alleged that the defendant, who was plaintiff ex-boyfriend, had unprotected sexual intercourse with plaintiff knowing he had herpes and without first informing her of same. Section 2307 imposes a duty to disclose, right? This comports with the plain meaning of the statute reference. When interpreting a statutory provision, we begin with the language of the statute, right? If the statutory terms are unambiguous, we construe the statute according to the plain meaning of its word. The dictionary definition of venereal disease is a contagious disease, such as gonorrhea or syphilis, that is typically acquired in sexual intercourse. Reference. Huh. That's written pretty good. Let's see. Such as gonorrhea, that is typically acquired in sexual intercourse. It's a reference. Or more succinctly, a sexually transmitted disease. Reference. While gonorrhea and syphilis are listed as examples in the Merriam-Webster dictionary definition, they are not exclusive examples of contagious diseases typically acquired in sexual intercourse. According to the Centers for Disease Control and Prevention, genital herpes is a sexually transmitted disease, STD, caused by the herpes simplex virus type 1, HSV1, or type 2, HSV2. Reference. It thus squarely falls within the definition of a venereal disease and therefore within the ambit of Section 2307. All right, I know Atmos read this. Let me see. Finally. All right, I'm just scanning out because I know Atmos already read it. So, and I'm reading it kind of rough. So let me see what else can I pick out to see. All right, let me look at this. It says the court found it significant that while there are mandatory testing requirements relating to those suspected of being infected with the venereal disease, the New York statute legislator had specifically excluded persons suspected of being infected with the HIV virus from being compelled to undergo such testing. Reference. It appears, therefore, that the Plaza Court relied on the fact that the following the enactment of Section 2307, the New York statute legislator had later enacted an entirely separate statutory scheme specifically related to HIV to exclude HIV from Section 2307's ambit. No such entirely separate public health statutory schemes exist for genital herpes. As a result, the defendant's reliance on the plaza is no avail. All right, so they're saying that that reference is not even related. Okay, so they use that in support of HIV, but it wasn't used in support of what they tried to use. It was used in a prior case to support HIV. They tried to use it to support genital herpes, but the government is saying no such separate public health statutory scheme exists for genital herpes. So they're saying as a result, the defendant's reliance on plaza is of no avail. So they're probably defense is probably going to lose on that one. Okay. Let's see. Let me see what else I don't know. Well, this is crazy. Hold on. All right, let me skip the two. All right. The conduct of alleged in the indictment violates section 120.20. The section 120.20 provides that a person is guilty of reckless endangerment in the second degree when he recklessly engages in conduct which creates a substantial risk of serious physical injury to another person. Under New York law, a person acts recklessly with respect to a result or circumstance when he or she is aware of and consciously disregards a substantial and unjustifiable risk that the particular result will occur or the circumstance exists. Case law. As the New York Court of Appeals have made clear, the reckless endangerment statute seeks to prevail the risk created by the actor conduct, not a particular outcome, and the risk of injury alone will sustain prosecution. Okay, so they're pretty much saying due to the exposure and not the results, whether they got it or not. So that's what I was saying when I said they use the date, and they're saying like if you, regardless if you gave somebody some kind of disease or whatever, you expose them to it. They could have caught it. So that's what they're saying in that piece. Okay. Okay, that's a reference. Okay. Seriously physical injury means physical injury which creates a substantial risk of death or which causes death or serious and protracted disfigurement, protracted impairment of health, or protracted loss of impairment of the function of any bodily organ. And there's a reference. If I'm not mistaken, in the previous one of the defense previous motions, then they pointed out that they were saying like they were trying to distinguish between like death and the serious injury or what have you, like to the loss of limbs or whatever, in contrast of what they're saying here, and what they're saying here pretty much says protracted impairment of health or protracted loss or impairment of the function of any bodily organ. So they could be saying with the on that I could see was, let's see, a protracted loss or impairment of the function of any bodily organ. So they could be saying that due to the disease, the organ that disease affects and infects, it will render it unable to function normally. So maybe that's the argument the government's trying to say. Just taking a guess. Let's see, let's read. All right. Each of the challenge charges alleges that the defendant violated both New York Penal Law Section 120.20 in that he engaged in unprotected sexual intercourse with Jane Doe number 6 without first informing Jane Doe number 6 that he had contracted herpes and obtaining her consent to sexual intercourse in these circumstances. Such conduct clearly meets the elements of reckless endangerment in the second degree. And remember, I told you with each charge or count, the prosecutor have to prove each element. So they're saying that it meets the elements of that particular charge. It says, indeed, the New York Court of Appeals affirmed this very conclusion in similar circumstances. In People versus Williams, the defendant engaged in unprotected sex with the victim knowing he was HIV positive and without informing the victim of his HIV positive status. Reference. The district attorney sought and a New York grand jury returned an indictment charging the defendant in Williams with inter alia reckless endangerment in the first degree. That means inter alia again means amongst other things. In violation of New York Penal Law Section 120.25, which criminalizes recklessly engaging in conduct which creates a grave risk of death to another person under circumstances evincing a depraved indifference to human life, meaning you're acting without regards to human life. Something similar you guys may hear is, like depraved heart, like you heard in the Freddie Gray trial out in Baltimore. All right. It says the trial court held that the conduct at issue did not constitute first degree reckless endangerment and reduced the count of first degree reckless endangerment to second degree reckless endangerment in violation of the New York Penal Law Section 120.20. The appellate court and the New York Court of Appeals affirmed the trial court's decision. In so holding, the New York Court of Appeals found that the conduct did not meet the legal standard for depraved indifference because there was no evidence that the defendant exposed the victim to the risk of HIV infection out of any malevolent desire for the victim to contract the virus, or that he was utterly indifferent to the victim's fate. The New York Court of Appeals, however, affirmed the decision of the lower court to reduce the charge to reckless endangerment in the second degree in these circumstances. The conduct alleged in the indictment as a violation of Section 120.20 thus clearly constitutes reckless endangerment in the second degree and falls squarely within the New York Courts of Appeals holding in Williams. The defendant's arguments to the contrary are meritless, and the court should deny the defendant's motion. All right, let me click around here and check on y'all, see what's going on, see if y'all can hear. Y'all good? Okay. Pale Ease, you can't compare herpes and HIV. She says she don't need treatment medication. All right. All right, y'all good? I'm looking at the screen now. So far, seems like from what I've read thus far, and I'm on the screen with y'all now, that just probably everything in the from the parts that I've already read, that the judge is probably going to deny those parts in the defense motion. All right, let me see y'all. Let me see y'all good. Okay. All right. Okay, good. Y'all following great. Sorry about the rough read, y'all. I am sleeping. We're gonna get through it. Okay. Let me see what else. Okay. Ooh, let's read about this barred by the statute of limitations. Okay. They said it's not, the government says it's not barred by the statute of limitations. Okay, it says the defendant's motion to dismiss based on the statute of limitations is frivolous and demonstrates a fundamental misunderstanding of RICO. Oh, that's a shot. Mm-mm. Let me take me a drink of this soda. They get nasty. Okay, reference. The statute of limitations for a substantive RICO offense. The offense charged in count one is 5 years from the date of the indictment. Okay, reference. No person shall be prosecuted, tried, or punished for any offense not capital unless the indictment is found within 5 years next after such offense shall have been committed. So I don't know when count one was committed. Five years. Okay. Oh, so count one, that's the bribery charge, right? All right. So count one, this is where the statute of limitation is. Okay, let me come on in front of the screen. Let me explain this. Now I used to explain this probably close to 2 years ago. In the statute of limitation, right, there's something called tolling, right, which allows the judge to start and stop the imaginary clock with regards to a charge. That's with when it comes to statute of limitation. So because count one, that's the bribery charge, and because the person in that charge is deceased and or a crime was just discovered within recent, that's how that charge will be able to be within the statute of limitations, although it happened in 1994. All right. So 5 years of the indictment. So they had to have discovered that charge, discovered that crime within 5 years of the indictment. When that indictment was 2019, I believe, or is it 2020? Because she was added, right? So I don't know if it was 2019 or 2020. So 5 years. So it had to be discovered between like 2014 or 2015, depending on when it was added in that indictment. That's how that 1994 charge is going to be correct. Yeah, they only need to meet the statute of limitations on some of the charges, not all correct. No, on whatever charge, every charge should have a statute of limitation, unless it doesn't have one, like murder or something like that. But when you have statute of limitation, like I said, tolling is what the judge can play around with, right? So just say like we'll take one of the charges. And I'm not saying that this is actually what happened. I'm just gonna just say like if somebody was sexually abused 20 years ago, right? And they either didn't know they were being abused, or they, for some reason, and a very good reason, they couldn't come and report it to the authorities. That's when the judge would kick in tolling and say, well, that person didn't know that he or she was abused, being abused, or they were unable to come forward to law enforcement. Maybe they were threatened or something like that. And that's way the judge is able to manipulate that imaginary clock when it comes to statute of limitation, and is referred to as tolling, and that's TOLLING. All right. So it says, all right. Okay, it says that certain racketeering acts are predicated on violations of state law does not mean that state statutes of limitations apply, as the defendant bizarrely asserts. Woo! Calling it bizarrely, calling them bizarre. Child, that is nasty, ain't it? Child, that old prosecution is nasty. All right, there's a reference. Nor is the applicable federal 5-year statute of limitation measured from the date of the first racketeering act. This is so because the defendant is not charged with committing a particular predicate act, but rather with committing racketeering through a pattern of racketeering acts. Under the law, in a substantive RICO charge under Section 1962C, the defendant must have committed at least one predicate act within 5 years of the date of the indictment. To establish a defendant's violation of Section 1962C, the government must prove that the defendant committed two or more predicate offenses, at least one of which occurred within the federal 5-year statute of limitation for non-capital offenses. Because this indictment was filed on June 20th, 2019, okay, see, I'm talking about, work with me now, work with me, I'm sleepy, okay, here we getting the dates now. Maybe I should wait till we got to the dates. At least one of the predicate racketeering acts charged against the defendant in the substantive RICO count must have occurred or continued past June 20th, 2014. Damn. There go the dates. There go the dates. In this case, racketeering acts 8 through 14 all occurred after that date, and there is thus no statute of limitations issue in this case. Oh, they act like they tired. They tired of this paperwork. That's what they acting like. All right, racketeering acts 2, 7, and 10 should not be dismissed. The defendant argues that racketeering acts 2, 7, and 10 of count 1, all of which relate to the production of child pornography, should be dismissed because there is no evidence that visual depictions exist. Reference. There is not a proper basis for a motion to dismiss, and the motion should be denied. An indictment returned by a legally constituted and unbiased grand jury, if valid on its face, is enough to call for trial of the charge on the merits. Case law. Unless the government has made what can fairly be described as a full proffer of the evidence it intends to present at trial, the sufficiency of the evidence is not appropriately addressed on a pretrial motion to dismiss an indictment. So remember, I said that a matter of law motion is what the defense put in, which is supposed to test the sufficiency of the evidence. The defense, which means the defense is saying the evidence is insufficient with regards to the acts that I just named off. The government is saying that, let's see, that it wasn't addressed properly on the pretrial motion to dismiss. So apparently somebody made a mistake in drafting that. So far, I'm seeing all these parts of the defense motion is you can reasonably, and I may be wrong. I don't know. I may be wrong, but so far I think she's going to deny the defense the defense motion to dismiss in these areas thus far. Okay, let's see. Okay, a defendant must wait until after the close of the government's case in chief at trial or after the jury's verdict before contesting the sufficiency of the evidence. Okay, so that is all that I just read. That is the time frame for a matter of law motion. It can come in before or after the jury verdict when it's contesting the sufficiency of the evidence. All right. There is a case law and a reference. Okay. It is well established that an indictment that is valid on its face may not be dismissed on the ground that it is based on inadequate or insufficient evidence. A defendant's factual arguments challenging, wait a minute, what is that? A facially valid, wait a minute, I can't see that. Challenging facially valid pleadings do not justify pretrial dismissal of the indictment. Okay, let's see what you're trying to say. The government is entitled to marshal and present its evidence at trial, and if warranted, have its sufficiency tested by a motion for a judgment of acquittal pursuant to Rule 29 of the Federal Rules of Criminal Procedure. Case law. As the government amply states in its opposition, while defendants' arguments may properly be considered on a motion under Rule 29 of the Federal Rule of Criminal Procedure, after the government presents its proof, they do not support dismissal of the indictment at this stage of the proceedings. A motion to dismiss a properly pleaded indictment confuses standards of pleading with standards of proof. Whoa, okay. So that means that when I told you a pleading is what you want the other side to do, and a motion is what you want the judge to do. And they're saying that um, this confuses the standard of pleading with the standard of proof, which is again that matter of law motion. All right, case law. So the defendants, however, had no basis to challenge the sufficiency of the indictment before trial because it met the basic pleading requirements and was valid on its face. Defendants will have other opportunities to contest the sufficiency of the government's evidence, but a pretrial motion to dismiss part of the indictment is not the time nor the proper occasion. Oh, okay. Here, the government has not presented full proper of its evidence. Hold on, let me go back to something. Hold on. Government evidence. I'm gonna look at that. Let me look at that case. All right, here the government has not presented a full proper of its evidence. Trial is scheduled to commence on August 18th. Oh, okay. So they haven't presented it all. So what is coming? So something else coming? Wait a minute, y'all. Hold on. So yeah, y'all work. Just give me 1 minute, okay? 1 minute. I gotta look at something. All right. Thank y'all for holding. Okay, you know what? I think it could be very well something Maybe some evidence of something is up under seal. I'm just guessing. And that's the only way the government, I mean, one of the only ways that the government can say that something is on hold or something, something is on hold. That's what proper means. Something is on hold. And the defense knows it. So therefore, they're saying they could be saying that they knew that since submitting a matter of law motion at this time was improper because the government case isn't in yet. Okay, well, I don't know what they're waiting for. I don't know what they're waiting for. Well, let's read y'all. Let's still get nosy. Let's get nosy, baby. Woo! Okay, it says venue in the Eastern District of New York is proper, as the defendant concedes his argument that the venue in the Eastern District of New York is premised on the court's granting his motion to dismiss count 6 through 9 and racketeering acts 12 through 14 of count 1 reference. Because the motion is baseless and should be denied, venue remain proper in this district. Okay. I mean, that was short and sweet. Why is it baseless? Why is it baseless? Let's see if we'll see. Moreover, the defendant is simply wrong when he asserts that count 6 through 9 and Racketeering Act 12 through and 14 of count 1 are the only alleged acts in the third superseding indictment that occurred within the Eastern District of New York. Racketeering Act 9 related to Jane Doe number 5, which the defendant does not challenge in his motion, is also alleged to have occurred within the Eastern District of New York and the Northern District of California and elsewhere. Okay. So, did they challenge 5? Hold on. Let me see. X. Okay. Count 6 through 9. I can say Act 12, 14. I know I had it. Wait. Sorry, y'all. We're doing this as we go. Let me see. What was it? Okay. So we had 12 and 14. 12, 14. Okay. 12 and 14 are the only acts in the third superseding indictment that occurred within the Eastern District of New York. Racketeering Act 9 related to Jane Doe number 5. The defendant does not challenge in its motion has occurred within the Eastern District of New York and California elsewhere. For the foregoing reasons. Okay, it cuts us right on off. Okay. Unmistaken. So, moreover, the defense is wrong when he asserts that count 6 through 9 and Racketeering Act 12 and 14 of counts 1 are the only. Oh, okay. More of the defendant is simply wrong when he asserts that count 6 through 9 and Racketeering Acts 12 and 14 of count 1 are the only alleged acts in the third superseding indictment that occurred within the Eastern District of New York. Racketeering Act 9 related to number 5, which is defendant. Okay. I guess it seems like they are, I don't know, seems like they're getting kind of tired of the defense because that venue response was really really short. I mean, it didn't really tell us what the government is trying to say more than it's saying you're wrong for challenging the venue. And remember, I was trying to tell Debo that when they're challenging the venue, they're challenging what jurisdiction it occurs, not should the tribe be moved this place and ever. No. They're challenging, the jurisdiction where it occurred, which is kind of similar, but it's different. Different in meaning, and it's also different in how it's handled, right? So based on everything I've seen, and the government, first the government said the government did say it was untimely. So if it's untimely, like I said, the that judge should. I'm not right. I don't know. Okay, I'm not on the case, but they should deny the defense matter of law motion. That motion they put in. What's still left outstanding is the reserve ruling for the uncharged acts. Right? So we're still waiting on that. Still waiting on that. And look at me, I'm just known saying that she's gonna deny the motion. So but we're still waiting on the judge to make um a ruling on that motion as well. But yeah, that's it. I mean, well, yeah. But listen, Golden, in when I did the live, what it was yesterday, the other day, remember I was going through, I was trying to see why is the defense challenging certain uncharged acts with regards to certain alleged victims and not the other. And let me get my paper. And let's see, when it came to Jane Doe number 7, 9, 11, 12, 14, and 15, that was pretty much with outside of 15, the rest of them was here, testimony, right? Not hearsay, but testimony. Nothing, no kind of direct evidence, right? Unless you know, count the herpes, but they're challenging the herpes for other reasons. So the herpes on 9, 11, and 12, they're challenging the herpes with those Jane Does. But with the other ones, it's testimony, right? And 15 is a challenge, I'm pretty sure, because that person didn't go to law enforcement. With the other ones, 8, 10, 13, 16, 17, 18, 19, and 20 is some type of direct evidence, some type of evidence, whether it be a pamphlet, an autograph, those letters, text messages, a video thread. You got the bus driver. We got the bus driver. And shout out to Larry. Oh Lord, shout out to Larry, Lord. But yeah, we have the photo. You got a photo. You know, yeah. So you have something. So that's different. So I'm interested to see how they're going to approach the evidence portion of it. Like, what are you going to do? What are you going to say with regards to the evidence? You know, and are they giving their client the real truth? You know, what's your real chances? Not like not the like say, oh, it's no hope or nothing like that. 'Cause that's definitely not what I'm saying. But you have to give, not scare them or whatever to where they do something crazy, but you have to give them the real kind of truth so they can make an informed decision about their defense. Because you're supposed to do what your client says, and you're supposed to give your client those options. Remember those options that I'm not sure if Greenberg was talking about these options, but the options usually mean what you're gonna do, what kind of defense you're gonna go. Or you want to talk about trying to get a plea, all of that. What you gonna do? Be realistic. Yeah, be realistic. Give them. You got to give it to them straight. They have to make an informed decision. Because if you don't talk it over with your client, every possible option, what have you, you're being an effective counsel. And so, because they're relying on you to educate them on what they're facing and all of that. So, I just want to see how in the world you're going to get to that evidence. This is what the government, what you're seeing for is the defense, the paperwork. And don't get me wrong, they put pulling out some very good points of what have you. But this is when you see the difference in someone that tries federal cases all the times or whatever. You're familiar with those codes, those time frames, and all of that. When you could do this motion, when you could do that motion, a lot of that stuff is specific. And when that government done hit you across the head talking about your motion is untimely, that's like a blow. I mean, you don't supposed to put this damn motion in, or it's too late, whatever. You know what I'm saying? Or it's too early, or something like that. It's like untimely. Shit, I don't know if Judge Ann work tomorrow, but she can knock that out tomorrow, if not tonight. If it's untimely, god damn. So that lets me, from judging by what it says, the government must be have some more stuff to go in. And is it upon? Let me see if I can get in the system, y'all. Just give me 1 minute. Let me see if y'all can work with them for a minute. Let me see if they can. What's up, Jojo the Ryan? Let me see if y'all got a minute. Let me see if there's something under seal that maybe haven't gotten under seal yet. Y'all got a minute? I can look at. Let me see if I can get in the system real quick. Let me know if y'all got a minute. Okay. All right. I'll look. Let me see if I can get in the system. I don't know why this thing is taking. Oh, the devil don't want me to get into that system, honey. Ugh. I couldn't get into it. I had to have somebody send me. I looked in and I saw Karen had to send it to me, but had to have Atma send it to me too. All right. I'm sorry. I don't know why I keep kicking me out. So I didn't see nothing. I have to go back and look. I don't know what it's doing, but I didn't see nothing. Um, yeah. So I don't know. I think, like I said, I think she's going to deny it. She's going to deny it. I believe they may see the defense may see something on on the on the uncharged act. Maybe they get a break on the uncharged act ruling. I know Diva was supposed to get the transcript from that pretrial hearing, that last one. So if she gets it, it should tell us what she already ruled on and what she has a reserved ruling on, meaning what we're waiting for. So, and we're impatient around here in the sector, both sides. We are impatient. So, all right. So that's what I have. I'll drop the link real quick. So if anybody got anything, if anybody got anything. Right, we like to know. We try to figure it out around these parts. We want to know what is going on. Where you at, Miss Lady? Where you at? How long is it gonna take? Yeah, right, Karen. Just bless the link and those that click it. Well, come in with no foolishness. Oh Lord, please. But isn't that crazy though? And see, that's the difference. If you don't know those federal rules, if you're not familiar with it, and but this is crazy. It doesn't matter whether it's a federal case or state case. When the judge when they give you the date, you have to have it in by that time. That's like a rookie mistake. I'm not talking bad about nobody, but that's like a rookie mistake. Like how you don't get it in by the date, and how you not be, and then well, oh, hold on. Wait a minute. Oh, let me look at something real quick. Hold on. I don't like to talk no trash. Hold on. Let me see what the untimely is. Untimely of the motion of law or the untimely. Okay. What's untimely? Okay. You know what, y'all? I think I misspoke. I think I misspoke. The case. Okay. They may have something outstanding to add to the case, and or it's also this motion could be untimely because of that first section there where it says the motion is untimely, where it says I'll reread it a little bit. That in transparent effort to avoid a finding that his motion is untimely, the defendant asserts that the motion is made pursuant to Rule 12b-2 of the Federal Rules of Criminal Procedure. His assertion does not make it so. Okay, so the defense asserted that Rule 12b-2. And what's 12b-2? Oh, y'all. 12B2 is a so 12B2. Okay, so there 12B2 is a lack of jurisdiction motion. All right. So some record something else could be dismissed because it a state claim under New York. Once dismissed, the bracket house account, the venue, blah 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 blah. Okay, in a certain aggregate related to the child pornography should be because there's no evidence child pornography exists. And all right. Yeah, okay. Wait a minute. Is there another? Okay, 12B2. Is it all? Did they all give it 12B2? Oh, it shouldn't. Okay, it should be something else other than 12B. Okay, they gave it a. Hold on. A 12B3. I'm sorry, y'all, I'm talking to myself. That's just how I work it out. 12B3. So 12B3 is a proper venue. So why did they do that one on the 12B3? Wait a minute. Okay, wait a minute. Deficit in the. Okay, no, but the federal rules make clear that emotions are larger. Deficit in, in why does it keep talking about the venue when they're saying racketeering acts related to the creation of child pornography should be dismissed because there's no evidence of visual depictions exist, and for some racketeering acts should be dismissed because they are purported beyond the applicable statute of limitations. So why are you doing all 23? Well, if the court is not set on the deadline, start trial, does not mean okay, well, but any court may consider defense objection request if the party shows good cause. But the federal rules provide a deadline for parties to make pre-travel. Why did they do it all up on the 12B2 and 12B3, which are all venue and jurisdiction challenges? But when they got, wait a minute, then they have, when they're talking about the child pornography, are they saying the child pornography is okay? Was the crime? No, the crime is the child pornography. That not that the child pornography was created in New York or Illinois or something like that. Or is the challenge? Are they challenging that it was created in Illinois, in New York? But that'd be stupid because y'all, I'm rambling. I'm talking to myself. I'm sorry. But that'd be stupid because the child pornography that's a crime in and itself, regardless of where it was created. So why did they all put them up under those challenges? That's interesting. Okay. Huh. Yeah. So I'm pretty sure she's gonna throw this. Yeah, she's gonna deny that pretty much most of this, if not all of it. Hey, I try. I try. I have no idea why they would put it off, but I'm gonna look into that a little further. But that's troublesome. Troublesome because you got to know your codes. What you're challenging. What's your argument? All that's about venue and which is a jurisdiction and all of that. That don't have nothing to do with child pornography or sexual abuse or whatever the charge is relating to depict, making those videos or whatever. Anyway, yeah, honey, I had a whole bunch of requests for me to come out and explain this. I did a rough go through, but listen, did y'all get some out of it? I want to make sure y'all got some out of it so y'all understood, pretty much what I think is going to happen with this. Oh, daddy's home. It sure is. The game round through. Um, y'all Did y'all get something out of what I was talking about? Okay. I'm gonna make sure y'all get something out of it because. All right, thank you, Mocha. Thank you. Yeah, make sure. Like I hope if I can remember something, I'll come back to the screen and see if y'all have any questions. But yeah, I had to look into why they use those codes. I don't know because that has nothing to do with child pornography or sexual. Think sexual abuse. Is it sexual abuse in this racketeering? It's not child pornography. Is it sexual abuse? Right? All right. Thank you, y'all. Thank you. Thank you. Y'all so sweet. Robert, that is not, just because you might have fellow experience, but do you have fellow experience with these type of cases? Like I said, you have to know these rules and stuff and these times and all of that. You got to know when you can put stuff in. This is crazy. Yeah, they threw some shots. They look like they was the prosecutors look like you don't know this. But I thought they referenced something about the date. Okay, I ain't gonna hold y'all no longer. I just want to look at something about the date. They referenced something about the dates. Okay. And here the court set a deadline for parties to make final pretrial motion from several adjournments of trial. The court said that with such motions, with consent of the defendant move on with extension as a result of the motion. Okay, and they're also saying that not only is this motion untimely, right, the one they put in, but you could have put in a pretrial motion, like a motion of limine, which is what they asked for, to preclude and exclude this stuff, and they're saying they didn't do that. So the prosecution is using a extra, you know, an extra backup saying, hey, it got to be it's got to be denied for untimely. And it's also citing that in Judge Donnelly, that's what they're saying, Judge Donnelly, and you gave him extra time to do it, to do a motion of limine. And they didn't do it, they didn't do that. They said, they submitted an opposition to our motion of limine. Yeah, instead of putting it there. So she should get to this tonight. Yeah, this is crazy. She should get to this tonight. God damn. Oh, this is terrible. Oh Lord. Y'all got JoJo in that act talking about the link. Yeah, that was okay, Miss Angie. Did you check for anything under? Yeah, I did. I didn't see anything. I'm gonna check it again. I'm gonna go back up a little further to see because it could be, like I said, it could be some more. They got some more case to come in, and or they could be talking about it's untimely because of the reasons I read right up under it, which is the what did I read it as the okay, he has searched that. Hold on, wait a minute. Fail to state a claim under. Once the court dismisses those activities and count on this result. Goes on time. Defendant assertions must be made. Okay. Yeah, that I don't know. And and I had high hope for that material that matter of law motion. I had high hopes for that. But that required, that judge to focus and right in and make that verdict, that right but that was gonna be like boom, right out the gate, right before the jury. And if I'm not mistaken, didn't it say that the defense was asking for the entire indictment to be dismissed? That could have been huge had it been submitted right. Damn. Shit. Damn. Boy, you can't win for losing around here, baby. It's a cold game. As Debo would say, boy, it's a cold game around here. Shit. Yes. Boy, that's a cold game. Yeah, I would. You kind of you want you don't want stuff that you want to kind of even out a little bit. You want like bam. You want nobody just bam, 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 bam. You know, just knock your head off every time you turn around. Hit you to the right, hit you to the left. I'm looking at that. Okay, here we go with the matter of law. Okay, okay. Somebody been doing that research. Somebody, damn, the shit ain't even shit can't be used. That's what pretty much means it's untimely. Can't be used. Shit. I did all that work. Oh man. Let me go and get out of here because this is crazy. This is crazy. All right, y'all. Let me go and get y'all out of here. Thanks again for the host and hostess and guests and everybody else. Till next time. Bye, y'all.